people to participate. He used the word free for all. That freaks me out a little bit. So I will encourage people to participate with Bill during his presentation, ask questions, but in order to make this manageable so that we're not listening to barking dogs and happy children and Amazon delivery men in everyone's location, post a question in the chat or raise your hand. I'll be monitoring that. If you have a question, if you have a comment that you want to add to Bill's presentation, let's go ahead and use that technology so that we keep the delivery of information nice and tidy. Does anybody have any questions before we proceed? Seeing no raised hands, no chat messages, I'm going to turn this over to Bill. Bill is an attorney who has been representing the North Carolina Association of Realtors for longer than he probably wants to admit. And he can finish introducing himself and letting you know what he's here to tell us about. Bill?
Thanks very much, Todd. Well, good morning, everybody. Welcome. Just a minute or two about myself. I've been practicing this year. I've been practicing law for 40 years. Originally a Yankee. I grew up in New York, but found my way to Chapel Hill for law school back in 1977. Got out in 1980. Got to see Phil Ford play basketball back in Carmichael Gym. Met my wife in Chapel Hill. Both my daughters graduated from UNC Chapel Hill. My mom lived in Chapel Hill, so I've spent a lot of time in your area. I love it. I was practicing law here. I moved back to North Carolina. I actually practiced law in Chicago for 16 years, moved back to North Carolina in 1996 and got to be good friends with Will Martin, who many of you may know was an in-house attorney with North Carolina Association of Realtors. Back in 2005, Will and I decided to form a law firm so that we could represent not only the North Carolina Association of Realtors, but also real estate firms, local boards around the state, individual brokers, and that's what we've done. And I think we've got a really unusual practice. A lot of, just a huge percentage of what we do is representing real estate agents. And so we are dealing with the issues that you deal with every day. Will has been on the forms committee over at NCAR since 1996. When these forms get revised, he's in the room. He understands why they're being revised, and so this is not an unusual thing for us to do to sit down with a group of people and talk about changes to the forms that are put into effect almost every year on July 1. So this is really timely. I mean, these new forms that we're going to talk about today have only been around for a couple of weeks. Only been effective for a couple of weeks. And there are not a ton of changes to talk about. I want to go through them. If you were inclined to take notes, don't. I'm going to try to use this technology and share my screen and show you how you can access pretty much all of the information that I'm going to give you today, as well as marked up versions of these forms. So let me give that a shot. And I'm going to be minimized here from now on as we go through these forms. Host disabled participant screen sharing. Is Cub there?
Hold on.
Cub, where are you?
Yeah, hold on.
All right.
What in the world has happened? Okay, now you go.
There we go.
Sorry about that.
Okay. Let's see. All right, let's see if this works here. I'm going to try to. All right, so this document that I'm going to be referring to is at the NC Realtors website, which is ncrealtors.org. You can see that up here. The first thing you got to do is you got to sign in to get to where I want to go. So hopefully, in order to sign in, you're going to need two things: your NERDS number and your password. So I'm going to type mine in. And I apologize for this little delay, but okay. Once you sign in, this is in the member-only side of the realtor's website, and you got to sign in order to do everything else that I'm going to do today. But so here, there are only about 4 steps to get to the document that you want to get to. The first step is to click on this Q&A link up at the top. So I'm going to do that. And it gives you all of the Q&As that Will and John Waite and I have written over the last 10 years. And they're divided up into categories. We're going to go to the category for forms. And when you click on that link, you get a bunch of choices. And there's this, summary of forms changes. Try that again. And here are all the summary of forms changes that have happened over the last few years. The one that I'm going to go to is summary of July 2020 property management forms changes. And I guess I've got to open this document down here. And up comes this document. Almost everything that I'm going to talk about for the next half hour or whatever is on this document. And not only that, but if you click on the links, what you're going to get are marked up versions of these forms. So I'm going to go through them in the same order that's on here. And the first one I'm going to talk about, and the 2 most important ones that I'm going to talk about are the property management agreement and the lease, both of which have a number of changes. So here's the property management agreement. And this goes in highlighting and cross-outs all of the changes that have been made. So I'm going to go through them. And kind of talk about them. And in this document, they're all in yellow, so they're easy to find. So the first change is in paragraph 3B. Now, paragraph 3 of the property management agreement is the section that talks about fees. And this part up here, 3A, talks about the typical fees. You know, percentage of rent. Some managers put in A2. You know, what if the property is not vacant? Some property managers charge a fee even when the property is vacant. So none of this has changed. But there's always been a section down here, 3B, where what happens if a tenant enters into a contract to buy in paragraph 3B to get a fee. This says my connection's unstable. That's not good. Hopefully that's not going to stay that way. So the change in this section is very minimal. What this section says is if the property manager can get a fee if a tenant enters into a contract to purchase the property. When? Well, if it happens when the property management agreement is in effect, you can get a fee. And it also says that if your property management agreement ends, but the tenant has a lease that extends beyond that. So let's say your lease ends let's say you sign a tenant up for a lease for calendar year 2020, but your property management agreement ends on July 31, but the tenant is still in there for the balance of the year and he enters into a contract to buy the property, you can still get a fee. But the change here from the word leases to occupies is what happens if there's a tenant in the property before your management agreement is entered into. And then you enter into the management agreement, the tenant is still there, and then the tenant enters into a contract to buy the property. By changing the word leases to occupies, you're now going to be entitled to a fee. Because that tenant didn't lease the property when you were managing it, but they did occupy the property when you were managing it. So that's the purpose of this change. All right, next, paragraph 6. This whole section talks about, like it says, authority and responsibilities of the agent. What the property manager is authorized to do, what the property manager is required to do. And paragraph 6A used to describe the property manager's duties to be to manage the property to the best of the agent's ability, devoting such time and attention as may be necessary. Well, a group of property managers got together and decided they wanted to change that language. Now that's pretty open-ended and vague language. And in my view, it got replaced by some pretty open-ended and vague language. Now what it says is that an agent's got to use reasonable skill, care, and diligence to manage the property. I think it's still a somewhat subjective standard, but reasonable care means, I think what they do is what's reasonable in your community. What do other property managers do? Are you doing are you meeting the community standard for property managers? Are you using a reasonable amount of skill? And I think property managers felt like that was a better standard to try to meet. It's less open-ended standard. Okay, so Todd, I'm going to assume that there are no questions, and I think, do you have the ability to unmute yourself?
That's right, Bill. I'm watching the chat. If anybody raises their hand or posts a question, I will let you know.
Okay, that's great. That's great. So I'm just going to continue on with these things. Paragraph 6F is the next one. Again, this is in that whole section of duties and responsibilities. It's always, the agents or property managers have always had the ability to make repairs that are necessary, but there's always been a limit on that. They can't arrange for repairs that exceed a certain amount, and that amount can be negotiated without getting prior approval. We've added now that prior approval has got to be in writing. And this was a change that was actually requested by the folks at the Real Estate Commission. So maybe my guess is that there were some property owners that were upset that property managers spent a bunch of money and there was a dispute about whether or not the owner had authorized it. So this is a change that eliminates confusion. If you're going to spend more money in the future than whatever number you fill in paragraph 6F, you're going to need to get written approval. So that's an important change.
Bill, Vicki would like to comment.
Is she unmuted?
I'm working on it.
All right.
I am now. Can you hear me?
I
Yes.
can.
Okay. Back up to 6A.
Right.
The part where it says, to the best of an agent's ability, devoting thereto such time and attention as may be necessary. I think when we were talking about all this, part of it was that sometimes that could get very extensive, and the rewording kind of took some pressure off.
Okay. Thank you, Vicki. Vicki, you're on this committee, aren't you?
Right.
Right. Okay. Well, I don't mean to say it's not a good change. I mean, it's, best of ability seems like it could be a lot. That could put a lot on a property manager. So
Devoting the time. I mean, if this is going to turn into something that's going to be hours, days, weeks, months, then maybe this is something that should be charged for, or not just the normal management fees.
right. All right. Well, thanks, Vicki. I appreciate the input.
And Bill,
keep it up, because I know you've been involved with a lot of these changes. So your input would be valuable and appreciated.
Bill, may I ask a question about 6F?
Sure.
Is not our authority to make repairs written in this contract? Or are you telling us that we need written approval for every repair?
No. Says agent may not make arrangements for repairs that exceed blank. And that's a negotiable number. So, you may have an owner that says, look, anything that you've got to do up to $500, so you don't even need to call me. Just do it. But if it's over $500, I want to know about it. I need to approve it in advance.
All right. Thanks for sharpening that a little for me.
Okay. All right. Paragraph 10D. Paragraph 10 talks about owner responsibilities, and paragraph 10D is all about insurance. And a number of the changes here were to kind of update the terminology. There's always been a requirement to maintain or to carry certain types of insurance. We used to call it public liability insurance. I think the current term of art in the insurance industry is comprehensive general liability insurance. So that change was made. We used to refer to personal injury, and insurance policies, I think most people probably know, they don't really refer to personal injury, they refer to bodily injury. So those changes were made. This says carry and maintain continuously. So just clarifying that, it's not enough for them to purchase the insurance, they got to keep it in place. And then a new sentence was added at the end of paragraph 6D, a suggestion to the owners that they should consult with an insurance professional regarding how much insurance they need. That is something, property managers are not insurance agents, generally speaking. That's beyond your pay grade to try to figure out how much liability insurance they should have. And so here's something telling them, go talk to a professional about that, about how much insurance you need. Some of these things, these changes that I'm going through, they're just paragraph numbers that I think were wrong in the old form and they're being updated. The next change of any substance is paragraph 23, which always talked about sale of property. And basically until now, all it had were requirements for the owner to notify the agent that they were selling the property. That was 23A. And they also had an obligation to notify the agent if the property went under contract and when the sale date was going to be. That was 3B. Well, we've now added a sentence, and by the way, most of these changes are done for the benefit of property managers. This is a good example of it. Here's one that allows an agent to negotiate for a fee if the owner is involved in trying to sell their property. Why? And this is something that's coming up more and more in COVID. Our lease gives landlords the right to enter the premises for purposes of showing it. But in order to show property before a contract is entered into, someone needs to contact the tenant and make arrangements. And that's extra work for a property manager that they never had to do. They wouldn't have to do in the absence of a property being for sale. And so this gives the agent an opportunity to get paid for that. And that extra work doesn't end once a contract is signed, because a buyer, if there's a buyer for the property, they want to conduct due diligence. They're going to want an inspector to get in the property. They're going to probably want an appraiser to get in the property. And who do you think is going to make the arrangements to do that? It's going to be, who has the relationship with the tenant. It's you, the property manager, and so here's an opportunity to get a fee for that. So that's changed to paragraph 23.
Bill?
Yes.
Just wanted to make sure that they realize that this is separate from any commission.
Right. In addition to anything that's in paragraph 3.
Right.
And or yeah. I mean, some property managers, I suppose, could end up as the sales agent as well. Yeah, and that would be covered in probably in a listing agreement. If they're actually marketing the property. All right, sorry about moving this around. Paragraph 33 is a brand new paragraph. Any property managers that are also involved in sales will recognize some of this language because it's always been in our listing agreement and our buyer agency agreement, or it hasn't always been, but it's something that's been in there recently. And it has to do with surveillance devices. More and more property owners have surveillance devices, whether they are cameras outside their home, whether it's a Ring doorbell, it could be an exterior mounted camera that they have in place to make sure that nobody's, messing with their property. And they could have stuff inside their property as well. And one thing, the law on surveillance devices is interesting. In terms of audio recording, it is illegal in North Carolina to record a conversation unless, number one, you're a party to that conversation, or two, you have the permission of one of the parties to that conversation. So for an owner to put an audio device in a leased property and without the knowledge and consent of a tenant, would be illegal. Video is permitted. You're allowed to have a Ring doorbell without the consent of anybody. You're allowed to have an exterior mounted camera or even an interior mounted camera without the consent of anybody. But people have somewhat of an expectation of privacy. And in the sales context, so for example, somebody's going through your house, they might not expect, you've made your house open to the public for people to come in and look at it to buy it. But in the bathroom, somebody might want to use your bathroom. You can't have a video camera in there, so there's an expectation of privacy. So you can't have that. So, but in a landlord-tenant situation, tenants have an expectation of privacy everywhere in their property. And so paragraph 33 has basically, covers this, kind of letting owners know what they can and can't do. And there are really two parts to this. One part is the disclosure, and the other part is removal. In terms of having if there's a video or any kind of surveillance device anywhere on the property, they agree that if the property is occupied, they have to disclose the existence of any device. They have to disclose the existence to an agent so that the agent can disclose it to a tenant. And they also, there's an obligation to remove devices, and it's two parts there. Anytime the property is occupied, they agree to remove or disable any video or audio surveillance device inside the property, and to remove or disable any audio device outside the property. So what that means is you're allowed to keep a video device outside the property. You just have to disclose it. But audio's got to be removed entirely once the property is rented. And then this warning is also new, kind of telling people this is a law. It's federal law, state law. You can't do it without consent of a party. So that's all new. Okay, last change. It's taking me a half hour, so this is going to take longer than I thought, but this whole thing shouldn't take more than an hour, I don't think. The last change in this property management agreement is in this section right above the signature lines, which is the non-discrimination language. And the first sentence of this ends with the clause, you have to do it without respect to race, color, religion, blah, 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 of any party or prospective party to the agreement. We had the words to the agreement in there. Well, this language is required by a real estate commission rule. The real estate commission rule doesn't have the words to the agreement. And so the real estate commission said, please take those words out of this document. So we did. The second sentence really relates to the Code of Ethics. The Code of Ethics has broader non-discrimination language. It includes, among protected categories, sexual orientation and gender identity. But because we had the words to this agreement in there, we took those out as well, just to be consistent. And I should point out that this change to this non-discrimination language was made in a number of different forms. I'm going to reference that later as we go on. All right. Let me go back. That is it on the property management form. So I'm going to go back to this document, which I told you how to access, and go to the next document, the rental contract. And again, this is the other really important document with some important changes. So the first one is, we've always had in here the premises where you put the address and everything else. The word premises is used a lot in this contract, in this lease. And here we've added some language to clarify the fact that the premises doesn't include just the interior of the dwelling unit. It includes stuff that's outside the dwelling unit, including outdoor areas, front and backyard, as long as those areas are in the tenant's exclusive control. So the premises, if in a multi-unit facility, there's probably the dwelling unit may be the only part that's within the tenant's exclusive control, maybe a storage unit. But in a single-family home, that front yard, backyard, exterior, that's all in their exclusive control. And so the premises, we want to make clear the premises includes that as well. Next change is down here in paragraph 1, and this is purely a formatting change. Paragraph 1C now has two sub-paragraphs, I and little II. These were always, this was always just one long thing. And by breaking it out into two sub-paragraphs, it's the point here is to make clear that, and by the way, this section 1C only talks about termination of a tenancy at the end of a renewal term. If you're terminating a tenancy at the end of the initial term, that's covered by 1A. But if the lease has been renewed, you go to 1C. And leases can be renewed on various bases. One way they can be renewed is on a calendar month-to-month basis. And then there are a variety of other ways. Well, if you're terminating a tenancy that's been renewed on a calendar month-to-month basis, you go to 1CI. If it's being renewed on any other basis, or if it has been renewed on any other basis, and you're terminating it, you go to this 1CII. Just hopefully clarification. Paragraph 4, tenant security deposit. This important change, I'm surprised in a way that this language wasn't in there earlier. This always says tenant security deposit is administered in accordance basically with North Carolina law. But the language now that we've added makes it clear that the tenant security deposit has to be paid prior to the tenant occupying premises. So an important change. I guess, I'm guessing that wasn't in there before anywhere else. So it's good that it's in there now. All right, paragraph 5, there are a couple of changes that are sort of related. Paragraph 5 talks about what are the tenant's obligations under the lease. And so paragraph 5I always had this language about not deliberately or negligently destroying, damaging, or removing any part of the premises. And we put in parentheses, including things like appliances and fixtures. Okay. Well, this bit about the appliances and fixtures and facilities, that was always in paragraph 11 of the lease, and we put it in here as well. We've taken that out, and we've kind of put that into 5J. And we've kind of made 5I clear that what we're talking about here is damaging the premises, whether inside or outside of the dwelling unit. And what is the premises? I guess, the premises are the rooms, the exterior, the walls, anything that's really sort of part of the real estate. And 5J separately says tenant is also responsible for any damage of any property that's inside the dwelling, including appliances and fixtures. So the whole idea here, and 5J used to be, like I say, in paragraph 11. We've moved it here because it just sort of makes sense for it to be right here next to 5I. And when you read 5I and 5J together, it's pretty obvious that the tenant's not supposed to damage either the real property or the personal property that's in the premises. And if they do, well, they're going to be responsible for the damage that they cause.
If anyone else is monitoring the chat, Vicky has pointed out that the changes in that section were added for things like pets destroying landscaping. If you've ever had a digging dog, you understand how expensive that can get.
Very good. And I think there's something about pet damage, later as well, but yeah, thank you. All right, paragraph 11, and this is sort of a change related to these changes to paragraph 5. Payment for repair of damages. Well, here, this first sentence is the sentence that was moved to paragraph 5J. And we just thought it made more sense for it to be, it even talked about tenant responsibility. Well, let's put it in the tenant responsibility section, and that's where it is. So we haven't taken that out of the lease, we've just moved it. But here, damages, it says, all right, we make it clear that if they cause damage, they are going to have to pay for it, any of that damage. And what we've done is added some examples of some additional examples of damage. We always had in here, such damage may include damage to window panes, screens, ovens, refrigerators, things like that. We've added some things, mostly exterior things, shutters, and then here's what Vicky was talking about, and lawn, shrubbery, or tree damage caused by tenant or tenant's animals. So made that clear. Okay. Pets. So this always, this unless permitted by a pet addendum, there was in a provisional lease, you're not allowed to keep a pet. And if you do have a pet and you violate this, you have to pay a fine. Well, I think there was some belief by tenants maybe that if they paid the fine, that kind of entitled them to keep the pet. Well, we've added language that makes it clear, no, payment of a fine does not permit a tenant to keep an animal or a pet for which the fine was imposed. You pay the fine, you still have to get rid of the pet. And if you don't, that's a violation of the lease for which, lease termination and eviction is a remedy. It is a remedy. Paragraph 14 is kind of similar to paragraph 12. You're only allowed to have the permitted occupants that are identified at the outset of the lease. And then if you violate that and have someone who's occupying the premises who's not a permitted occupant, there's a fine. And again, I think some tenants believe that if they paid the fine, that gave them the right to have the permit, a new permitted occupant. Well, no, that doesn't do that at all. That doesn't, there's a fine, but you still cannot have that person there. They can't occupy it or use it as a residence. And like it is with pets, that's a lease violation. And if it's not cured, it can be a basis for termination of a lease. Paragraph 17, A2. I think this is a really, small, there are not a lot of words here, but to me it's a really important clarification or change maybe to this lease. So just to take a step back about breach, And, just as a reminder to people that do summary ejectment, there are basically two kinds of breach in the lease, of the lease. One is the failure to pay rent, and the other is everything else. And they're treated differently. Under our lease, if a tenant fails to pay the rent and is due on the 1st, you don't have to give the tenant 5 days to pay their rent or 10 days to pay their rent. You don't have to give them any notice at all. The failure to pay rent on time is a breach of the lease that entitles the landlord to terminate the lease or terminate the tenant's right to possession and demand immediate possession of the premises without notice. There's a lot of confusion about that. But for any other lease violation, any other breach of the lease, that's not the case. 17A2 says that a breach is if tenant fails to perform any other obligation, perform any other promise, duty, or obligation herein agreed to by him or imposed upon him by law, and such failure shall continue for a period of 5 days from the date the landlord provides tenant with written notice of such failure. That's all it used to say. So if the tenant, for example, was smoking and you didn't want the tenant, that violates the lease, or the tenant was creating a disturbance and was bothering other tenants, you couldn't just terminate their lease. You had to give them notice, and you had to give them 5 days to cure. And if they stopped smoking and they didn't cure, or they stopped creating a disturbance, that was not a basis to evict them. You couldn't terminate their lease. But what if they started up again? If you gave them notice and they were good for 5 days, and then a week later or a month later they start smoking or they start creating a disturbance? Did you have to give them additional notice? And the answer is, with this new language, it is clear you do not. A breach is, if it continues for a period of 5 days, or shall occur again any time thereafter without any requirement of further notice from the landlord. So if they do it again, it's a breach. No notice is required. You can terminate their lease or terminate their right to possession, demand possession immediately, and if they fail to give you that possession, you're entitled to file a summary ejectment action against them. So once is enough for any other lease violation. I think that's really a big deal. Only other change is here where you're supposed to itemize contract addenda. For some reason, we've had this military status addendum since I think 2016. We've had this assistance animal addendum since 2018, but we never added them to the checklist. This guarantee addendum, which I'll talk about here in a little bit, that's new this year. So we just added these check boxes, and if they're part of the lease, you can check the box. And that's it. That's it on the lease. Those are the two big ones. So everything else, let me talk about this one, the pet addendum. This one's been changed. If anybody's familiar with this form, you can see it's got a lot more words. So it used to be paragraph 1, it used to say type of permitted pet. I think there was like one line, and I don't know what people put in there. Dog, maybe the breed. I don't know what they put in. But now we say, we've added a bunch of lines. We say description of permitted pet, and breed, color, age, weight, name. So so there's going to be a clear identification of the pet, and that animal is given a defined term. It's called the pet, and so throughout the rest of the document, that animal is referred to as the pet. And we've added this language as well. Tenant acknowledges and understands that this addendum applies only to that pet and not to any other type of animal unless the pet is replaced pursuant to paragraph 3, and I'll talk about that in just a second. So more descriptive language in paragraph 1. So paragraph 2 really didn't change much, other than it always had a sentence that dealt with the pet fee, and the second sentence always dealt with damages. And so now we've added the word damages to the title, so to make it clear that it covers both the pet fee and the damages. Removal of pet, again, I think this was always here as well. Basically, if this pet is causing a problem, and they've paid a pet fee, but the pet is causing a problem, in the landlord's sole judgment, the animal's got to be removed. But that doesn't mean that the pet can't be replaced, and without the requirement of a this now makes it clear that if you replace that animal, there is not an obligation to pay a new pet fee. And we also clarify that that replacement pet is going to be subject to all of the other terms of this addendum. Paragraphs 4 and 5 are brand new. These are basically identifying what obligations tenants have with regard to their pet. They're representing that the pet has been, to the extent applicable, licensed, inoculated for rabies, and neutered or spayed, which I think is interesting. To the extent applicable, I think that there's a state law regarding rabies inoculation of certain animals. I think certain municipalities have their own regulations regarding licensing, and so you need to familiarize yourself with that to know what the tenant is required to do. Paragraph 5 talks about care and control of the animal. Tenants responsible for feeding, maintaining, taking care of the pet. This prohibits tethering of pets when the pet's not inside. Also says that if the pet's outside, they'll be basically under control, on a leash, or carried, or kept in a fenced-in area. So this indemnity paragraph always had a requirement that they indemnify and hold the landlord harmless from any injury that results, any injury to third parties. But also now this adds some language requiring the tenant to take reasonable measures to prevent that damage to property or person. So just imposing some additional obligations on the tenant. The assistance animal addendum, I'm not going to go through this, but these changes essentially mirror the changes to the pet addendum. More description. This removal paragraph, for some reason 2 and 3 are flipped on the pet addendum. Removal of the assistance animal, this is allows that as well. Again, they can be replaced. The assistance animal can be replaced. There is no fee for an assistance animal. That's illegal. You can't charge a fee for an assistance animal. Damages, the word was always there for damages. This one, these are the same paragraphs, essentially the same paragraphs. 4, 5, and 6 are the same. So let's see. The right to lease form, this is form 405. This is the sort of limited services that some property managers provide. The only change here is this non-discrimination language that I mentioned earlier. So pretty insignificant. And last form to be changed, the vacation rental property management agreement. Again, the only change is to the non-discrimination language. Here, this language is right up at the top on page 1 not near the signature blocks. So those are the only changes. Okay, so those are the only forms changes, but in addition to the forms changes, there are actually 2 new forms, and there are no links to those forms. And so I'm going to see if this works. I'm going to So the first new form is a guarantee addendum, form 445. Let's see if I can get this to open. Here it is. So I think everybody's familiar with the whole concept of a guarantee. I wonder if it comes up a lot in your area with students. I wonder if people require parents to guarantee leases. My daughter's leased places in Chapel Hill. I vaguely remember having to either sign a lease or maybe sign a guarantee. But it's, everybody I think understands why you might want one of these. It could be a condition for a tenant renting the property, having someone sign a guarantee. And this lease basically says that if a tenant fails to make a payment, that the landlord can demand that payment from the guarantor. There is a state law, which I could show you. Actually, I think I will show it to you. This is in Chapter 26 of the North Carolina General Statutes, and it deals with guarantees, and it says, after any obligation becomes due and payable, any guarantor may give written notice to the holder of the obligation, requiring him to use reasonable diligence to recover against the principal and to proceed or to realize upon any securities which he holds for the obligations. So basically, what this statute says is that typically a guarantor can require someone like a landlord to demand first that they try to recover payment from the primary obligor. And we didn't want that. So we made it clear in this lease that a landlord is not required to demand payment from the tenant first. And so that's in paragraph 3, or excuse me, paragraph 2. Landlord is not obligated to first attempt recovery from the tenant for any breach of the lease, non-payment of rent, or any other financial obligations. The guarantor expressly waives any right under this statute to require a landlord to first seek recovery against the tenant. So if you've got a situation where a tenant's not paying, you can go right to the guarantor and say, pay. And if they don't pay, it's a breach of the lease. You can terminate the lease, terminate the right to possession. A couple of other provisions in here. This lease, this guarantee applies not only to, this is in paragraph 3, not only to the initial term of the lease, but also any extension or renewal of the lease. And you can have more than one guarantor. Paragraph 4 talks about joint and several liabilities. So that means if you've got more than one, you can go after any one of them. You don't have to go after all of them. You can pick and choose who you want to go after. So that's the guarantee, a good new form for you. The only other new form, Form 403, really a simple form, an agreement to amend the exclusive property management agreement. Paragraph 24 of the property management agreement talks about modifications to the property management agreement, and it says that they've got to be in writing and signed by all the parties. So how did you do that? You'd have to come up with something. Maybe people did. I don't know how people did that, but now you've got a form to do it. And it can be used for either the vacation rental property management agreement or the long-term rental property management agreement. and it can be amended however you want. Some agents may think that this is the unauthorized practice of law. You don't need to worry about that because your property management firm is a party to the property management agreement. You can revise any agreement that you are a party to. What you're not allowed to do is to draft language, revise language of agreements for others. And so those are the forms changes.
Bill,
Yeah,
we have a question from Evelyn in the chat. If you have a guarantor for each tenant, would you have each guarantor sign a different form? I assume we're talking about like a student rental situation where you have 4 roommates and all 4 of their parents are going to guarantee their lease.
yeah, I think that's a good point. I don't know how those leases work, Todd. Maybe you know for student leases. Are each of the tenants liable for the entire rent, or is each tenant liable only for their pro rata share?
Yeah, it's joint and several liability.
Yeah, so that raises a good question. I'm not sure. Vicky may want to weigh in on whether that was even discussed. Typically tenants have joint and several liability, and so the guarantee would be for the entire indebtedness, because the tenant has liability for the entire indebtedness, for the entire rent. So,
So
yeah.
to answer Evelyn's question, using my scenario, if a parent for each of those 4 students signs a guarantee, each and every one of those parents is completely responsible individually for the conduct of all 4 of those roommates. Or if only one parent signs a guarantee for their student child, that one parent is responsible for the conduct of all of the roommates, for the failure to pay for all of the roommates.
Right. I mean, Todd, my recollection is when I had to sign whatever I had to sign for my daughters, I was basically guaranteed. If I signed the lease, I was signing the lease for the entire obligation. If it was a guarantor, it was for the entire obligation. I don't know that it's possible to create a guarantee where you're only guaranteeing a share of the tenant's
Right.
obligation. The tenant has an obligation for the entire lease.
That's right.
And so I think the guarantee is for the tenant's entire obligation, which is for the performance of the entire lease obligation. Vicky?
My question is that there's only 2 blanks on the form. So I agree with you that the guarantors, their liability is joint and several as well. But if you have 4 guarantors, are we just going to recreate this form so that there's space for 4?
Well, or I think you can use separate. I don't think you need to have the same, everybody sign the same guarantee amendment, addendum.
So Bill, on the top line of that addendum is the tenant, then the landlord and the premises. So would you put all tenants' names in
I would list all the tenants for sure,
Okay.
but I don't think that all guarantors have to sign the same guarantee. I think it would be perfectly acceptable if there are 4 kids and 4 sets of parents to list all the tenants on each guarantee, but to send each set of parents a separate addendum, a separate guarantee addendum.
That's going to
I
be
haven't really
interesting
considered
next
that,
time. Next time somebody presents one of these to a parent and there are 4 names across that top line, I think that parent is going to stop and think for a second, which may be a very good thing for them, but maybe not so much for us.
Well, it's a good way for landlords to keep their property protected, because I think what it's going to lead to is a conversation between the kid and their child saying, look, you guys need to take care of that place because I'm on the hook for any damage. any damage, whether you cause it or your roommates cause it. So keep it under control over there in Chapel Hill.
So, Bill, we have a couple of questions in the chat. First, Garrett wants to ask a question about audio surveillance. Garrett, can you unmute yourself, or do I need to find you and unmute you?
No, I did. I hope you
Right
can hear
on.
me. Okay. So first, thanks for the interesting webcast. Bill, I'm a landlord and broker, and the topic of audio surveillance or not being allowed to do audio has come up quite a bit. And having some experience with surveillance equipment, I know that you can't really, or let's say it this way, every camera today is capable of recording audio, be it the Ring, be it whatever surveillance camera. And so I'm wondering what would be sufficient proof of disabling audio. When you have in the settings, you can disable audio, but you can as well, redo it. And so I don't see how you would have sufficient legal proof that you disabled audio. Makes sense?
Yeah. So first of all, is your question focused on the property management context?
Well, I think in general, you are not allowed as a landlord to have inside or outside, you said, outside video and audio equipment. And you are in general, you showed a North Carolina act where it says you can't record a conversation without being a party of the conversation, correct? Or having agreement. So in today's world, most surveillance devices can record audio. So, and it's very difficult, in my opinion, to prove that you disabled the audio function.
Right. Well, let me tell you something. In the property management context, I think it's inappropriate for there to be an interior surveillance device of any kind.
Great.
And so, if I were a property manager, I would insist that it's one thing to have a device. In fact, I don't see a problem even with an audio device while you're showing the property to prospective tenants or making the property available for prospective tenants before the property is leased, because I don't think there's any expectation of privacy, within limits. I mean, I don't no cameras in the bathrooms, but other than that, I don't see any problem. But once the property is leased, I think it's totally inappropriate to have a camera inside the premises. Now, on the exterior, I think it's perfectly acceptable to have a video device, I'm trying to think the best way to handle this. I think that I think if it's disclosed, if there's a device like let's say a Ring doorbell, there's an audio feature on a Ring doorbell, as I understand it. I don't have one. And I would think that landlords might want to keep that, but I think it needs to be disclosed to the tenant. I suppose give the tenant the opportunity to object to it. I'm trying to find that language in the lease or the property management agreement.
Bill, could I add something to this?
Sure.
I think our intent was that if the owner has this, then they disconnect it completely, or they can turn over that to the tenant so that they can use it as a protection, just like you would any other protection for the home.
Right.
That the owner still would not be controlling this stuff.
Right. I'm looking at the language in this paragraph 33, and what it says is that the owner agrees to remove or disable access to any audio devices located anywhere on the property outside any dwelling. So, but I mean, you're making, is it Garrett making a good point? How do you know that they've disabled the audio? I don't know that there's any way to know. And so
So
I think that is something that probably Vicky's right. I think it's something that it either has to be with the consent of the tenant or turned over to the tenant if it's an audio device, because I don't think there's any other way to know.
Yeah, I agree with Vicky. I think the only option is to either completely disable video and audio or to hand it over to the tenant. I agree with that.
Thank you
Thank
for
you.
the question. It's a good question.
Thank you, Bill. That was fantastic. Are there any other questions? Raise your hand, unmute yourself. We can have Bill's free for all now if you'd like.
Yeah, I am willing to answer any other questions. If there are any, on any other subject. I'm also happy to go get coffee if there aren't any questions.
Well, thank you, Bill. I trust you'll let us follow up with you if we get any questions that we feel like we would need some professional guidance on. We'll let you know.
Right.
Is that all right with you?
Yeah, absolutely. Let me suggest this. I mean, for anybody there may be some people here that are, I assume everybody's a member of the Association of Realtors. We've got a legal hotline, which many of you have used, some of you may not have used. And the way with COVID and people working remotely, the easiest way to get a question answered now is to email us. And this is something worth writing down. Is our email address. It's what you might expect it to be. It's legalhotline@ncrealtors.org. And if you email a question to that hotline email address, you will get a response that day. That is, if you email us before 5 o'clock, you'll get a response that day. You can also call NCAR's number. I think that's the easiest way to get us. Todd, is that helpful?
Wonderful. Fantastic. Thank you so much, Bill.
You are very welcome.
Very, very helpful.
Great day.
Thank you. You too. Before we adjourn, does anybody have any announcements, anything to share with the group? Any upcoming events you want to publicize?
Sorry, I have a quick question.
Go ahead.
I'm just wondering if there are additional guarantor need to sign, can we use additional signature addendum for that? Instead of use 2 pages of two same copy of the grantor addendum.
Yeah, let me just take a quick look at that form. I think that probably would work. 3T, let me just take a, I don't want to give you bad advice.
While Bill is looking that up, if you do have any announcements, if you have any events coming up you'd like everybody to know about, throw that up in the chat for us. And I did ask Cub to record this. I don't know what you do with that recording, Cub. I don't know if you send out a link to everybody so that they can go back through Bill's review, but I know we have it documented.
Todd, it will be sent out. We will give it to you to put it in the Google chat as well. And we also will send it out in our weekly emails.
You're the man.
And one more thing is that all of this that was changed came from questions that were sent to the legal group. So if you have questions and concerns, that's where Will Martin pulled all these things. So.
And to answer the earlier question, I think the additional signatures addendum would work just fine for that. So I think that would be fine. And just as a reminder, watching this video might be painful, but the document that I referred to is available on the Realtors website. And really what I did today is go through that in a little bit of detail. But that document is really helpful. So I would suggest people go there.
Fantastic. Well done, everyone. Our first Property Management Council Zoom meeting, and I thought we had very good Zoom hygiene. Very, very pleased with the number of participants. Thank you again to Bill and Cobb and Vicky and everyone who participated. Barring anything popping up in the chat to slow me down, I'm fixing to adjourn this.
All right. Thanks, guys. Take care.
Thank you, everybody.
Thank you, everybody.
Bob, I'll see you next week.